Good evening, everyone. My name is Rose Cuizan Villazor. I am the interim co-dean of Rutgers Law School on the Newark location. Welcome to the 37th annual Chief Justice Joseph Weintraub Lecture. And just to make sure that I properly welcome the people, the dignitaries who are here, I wish I could say hello to every single one of you, but then that'll take some time away from Judge Karchman. But I do want to say good evening to Chief Justice Stuart Rabner, Judge Jack Sabatino, who is temporarily assigned to the New Jersey Supreme Court, as well as former Chief Justice Deborah Poritz, and former Justices Barry Albin and Virginia Long. Thank you so much, everybody, for being here tonight. Of course, I would be remiss if I do not welcome our distinguished alumni, and particularly the members of the Alumni Association, especially President Omar Barrento. I also want to acknowledge and thank the members of the Rutgers University Law Review for co-sponsoring this event with the Alumni Association of Rutgers Law School here in Newark. The Chief Justice Joseph Weintraub Lecture series was established by the Rutgers Newark Law School Alumni Association in honor of the late Chief Justice of the New Jersey Supreme Court. The series was inaugurated in 1982 by the late Chief Justice Robert Willans. We are so excited tonight to hear the Weintraub lecturer, the Honorable Philip Karchman, tonight. And in order to continue, let me now turn the podium over to President Barrento, who will provide some opening remarks. Thank you again for being here tonight.
Have to adjust this a little bit, sorry. Welcome members of the judiciary, faculty, students, and fellow alumni to the 37th Annual Chief Justice Joseph Weintraub Lecture. First, I would like to thank Dean Cuizan Villazor and Dean Steinbaum and the law school for facilitating and co-sponsoring this event with the Alumni Association. For those of you who are not familiar with Chief Justice Weintraub's career and legacy, he was the second Chief Justice of the New Jersey Supreme Court. During his 16 years as Chief Justice, he became known for his clear and concise opinions, which were intended to be easily digested by lawyers, judges, and the public. His decisions were based not only on constitutional and statutory principles, but also on common sense, the public interest, and principles of equity and even human rights, such as in a case involving a migrant farm worker's right to access government services. As one of Chief Justice Weintraub's law clerks explained in a law review article he authored 1 year after the justice's retirement, the Weintraub Court was a court of action in procedure, in administration, and in substantive law. Today, we commemorate the legacy of Chief Justice Weintraub through this lecture series. It is one of the Alumni Association's signature events each year, which it co-hosts with the law school. This year, we are delighted to welcome this year's lecturer, Judge Philip Karchman. Judge Karchman began his judicial career in 1973 when he was appointed to the position of municipal court judge of Princeton Township in the Princeton Borough. In 1981, Governor Brendan Byrne appointed him as a Mercer County prosecutor, and Judge Karchman served in that position until 1986 when Governor Thomas Kean appointed him to the Superior Court of New Jersey. In 1997, Chief Justice Deborah Poritz appointed Judge Karchman to the Appellate Division. Soon after, Judge Karchman became Administrative Director of the courts. In his 34 years on the bench, Judge Karchman has authored over 1,200 written opinions. Judge Karchman has sat in every judicial position in New Jersey, including temporary assignments to the Supreme Court. Most recently, Chief Justice Stuart Rabner appointed Judge Karchman as the 11th tie-breaking member of the state's Legislative Apportionment Commission. The commission was tasked with redrawing the state's legislative district lines following the 2020 U.S. Census. Like Justice Weintraub, Judge Karchman has served with integrity, with excellence, and with an unwavering commitment to justice. We are honored to have him as our 37th Annual Chief Justice Joseph Weintraub Lecture, and so without further ado, please join me in welcoming Judge Philip Karchman.
Thank you, this microphone goes down now. Thank you, Mr. Brinto, for your kind remarks. You've listened to the resume of someone who can't hold a job. That's really what it involved. Chief Justice Ravner and Chief Justice Poritz, members of the Supreme Court, both past and present, my former colleagues on the bench and the bar, my friends and other guests who are here tonight, and a greeting to my family. I appreciate your all being here. I'm waiting for two grandchildren who promised to be here but called and said they're stuck in traffic, but they'll make it. And to those who are on live stream, I give you a wave as well. You all honor me with your presence here tonight, and I am humbled to be here and join the many extraordinary judges and lawyers who have presented this lecture in the past. I especially want to thank the law school, the Law Review, Dean Kuzan Villazor, and especially Rob Steinbaum, who worked very hard to bring us to this evening. As I reflected on this lecture, I came to realize that I am one of a diminishing number of lawyers who had any direct personal interaction or professional interaction with Chief Justice Weintraub. And I remember my first encounter very well. Just 2 years out of law school, I had my first opportunity to argue before the Weintraub court, and I well remember a specific exchange that I had with the Chief Justice. I was the cross appellant in a case where the appellate division had granted relief that in my youthful view was contrary to the statute. Chief Justice Weintraub called on me to justify my legal position. I answered earnestly that I was relying on the language of the statute, concluding this was the law. The chief leaned forward and advised me in words that resonate with me to this day. We will tell you what the law is. Now, just a few years earlier, I had studied Chief Justice John Marshall's opinion in the 1803 case of Marbury versus Madison. And I read Marshall's words saying very much the same thing, but it is one thing to read it in a case book, and it's another to hear it as a stake in the heart of one's theory of a case. My later appearances before the Weintraub court were less memorable, but that first encounter remains indelibly etched in my mind. While my interaction with the Chief Justice was limited to my appearances before the court, I would not realize how much influence he would have on my efforts some 50 or so years later, when I was selected by his successor 5 times removed, Chief Justice Stuart Ravner, to serve as the 11th member of the New Jersey Apportionment Commission. For it was Chief Justice Weintraub who, through his judicial opinions, not only laid the foundation, but built the structure for the legislative apportionment process that now governs New Jersey's obligation to fulfill the constitutional mandate of one person, one vote. I have divided this evening's discussion into 2 parts. The first part will address a brief history of the Apportionment Commission and the case law that informed the Commission as to what the law is. For I believe to understand the present, we must study the past. For the second part of my talk tonight, I will provide a first-person account of my service as the 11th member of the 2021-22 Legislative Apportionment Commission. Part 1, History and the Law. Any history of modern legislative apportionment must highlight the judicial oversight that has been the hallmark of the modern New Jersey Supreme Court. However, a court's role in the process was not always a given. In 1946, Judge Felix Frankfurter in Colesgrove versus Green, writing for a 3-judge plurality, declared that the federal courts would not venture into the political thicket of congressional redistricting. He urged that, quote, the remedy for unfairness in districting is to secure state legislators that will apportion properly or invoke the ample powers of Congress. According to Frankfurter, the issue was not justiciable, and the Supreme Court would demur. This despite the fact that the offender state of Illinois had not redistricted in 45 years. More to our focus tonight, Colesgrove filed a second action, challenging the more malapportioned state legislative districts. The Supreme Court dismissed the second case, Colesgrove versus Barrett, for lack of a federal question. Colesgrove would remain the law for 36 years until a favorite son of New Jersey, Justice William J. Brennan, Jr., authored what he would later call the most important opinion of his Supreme Court tenure, Baker versus Carr, rejecting Colesgrove and concluding that the issue of redistricting was in fact justiciable. The genius of Justice Brennan was that he deferred the discussion of standards to be applied in the redistricting process to future courts, but the die was cast. Other cases soon followed. First, Westbury versus Sanders, decided in 1964, where Justice Hugo Black declared that Article 1 required, quote, as nearly as practicable, one man's vote in a congressional election is to be worth as much as another's. And just a few months later, in June 1964, Chief Justice Earl Warren wrote in Reynolds versus Sims that the obligation to redistrict applied to state legislators as well as state legislatures as well as congressional districts. He observed, quote, legislators represent people, not trees or acres. Legislators are elected by voters, not farms or cities or economic interests. The issue of justiciability of reapportionment was not new to the New Jersey Supreme Court. Even before the United States Supreme Court had overruled Colesgrove in Baker versus Carr, the issue of the 19-year failure of the legislature to reapportion General Assembly seats was before the court in Asbury Park Press versus Woolley, decided in 1960. Justice John Francis observed that when a sacred right is transgressed by legislative action, the final decision as to the invalidity of such action rests with the courts. He added, quote, the judicial department has imposed upon it the solemn duty to interpret the laws in the last resort. However delicate that duty may be, we are not at liberty to surrender or to ignore or to waive it. It would not take long for Chief Justice Weintraub and the court to advise the legislature and the public as to what the law is. Even before Reynolds was decided, the issue of the constitutionality of New Jersey's legislative scheme, and particularly the apportionment of one senator to each county, was squarely before the court. A lawsuit had been instituted claiming that the constitutional allocation violated the Equal Protection Clause of the 14th Amendment. After the Chancery Division rejected the claim, it was certified directly to the Supreme Court, and while it was pending, Reynolds was decided. The court moved quickly. As with so many of Chief Justice Weintraub's judicial opinions, his seminal opinion in Jackman versus Bodine was succinct and to the point. The New Jersey constitutional scheme of one senator for each county, without regard to population, was unconstitutional. And what about the General Assembly? The Chief Justice disposed of that issue directly. Relying on the United States Supreme Court decision in Lucas versus 44th General Assembly of Colorado, he declared that if one house of the legislature is malapportioned, the deficiency vitiates the entire legislative structure. Both houses of the legislature would be reapportioned. After disposing of the merits, the Chief Justice addressed the remedy. He observed that the apportionment must be accomplished through the legislature, cautioning that, quote, the prescription of a new plan of apportionment is laden with political controversy from which the judiciary cannot be too distant. He discussed alternative solutions, pressing the legislature to consider a constitutional convention, observing that the exigencies allowed the convention to be convened without the seemingly required popular vote. And then he applied the coup de grace as to the timing of the effort. He said, quote, "The legislative power may not be exercised after the second Tuesday in January 1966, except by legislators elected not later than November 1965 under a basis consonant with the Equal Protection Clause. An interim legislature was established to comply with the court's mandate, but the legislature had no choice. There would be a constitutional convention in 1966. The court would not yield oversight. It retained jurisdiction to resolve future disputes. In fact, there would be 8 opinions in Jackman versus Bodine addressing myriad issues that required resolution. With the exception of per curiam opinions, they would all be signed by the Chief Justice. The work of the convention is a lecture unto itself. The late Rutgers professor Ernest Rioch's History of the Convention reveals that a number of contentious issues dominated the deliberations. Would New Jersey have a bicameral versus a unicameral legislature? What would be the size of each legislative house? Would the districts be multi-member or single-member? Initial reapportionment remained unresolved until the convention agreed to a compromise, fashioned in part by a delegate, Senator Wesley Lance, who had previously served as a delegate to the 1947 convention. Among other resolved issues, New Jersey would have a bicameral legislature consisting of 40 equally populated districts with 1 senator and 2 members of the General Assembly, and whole counties would be the focal point of each district. Surprisingly, what was not contentious was the question of how state legislative districts would be apportioned in the future. Unlike the majority of states, where state legislatures retain the apportionment authority, the convention delegates from both parties strongly supported a bipartisan apportionment commission, independent of the legislature. The new apportionment commission structure was simple. The commission would consist of 10 members, 5 from each of the 2 parties whose candidates received the largest number of votes in the most recent gubernatorial election. Of course, this translated into 5 Democrats and 5 Republicans, with each delegation chosen by the respective party state chairs. The commission would be in place by November. The head of each delegation would serve as a co-chair, and the commission would start its deliberative process. And in the event that the delegations were unable to reach a timely agreement as to an apportionment plan, the commission would inform the Chief Justice, and then the Chief Justice would appoint an 11th member. The appointment would be late in the process, 1 month before the commission was required to certify a final apportionment plan, which was to be filed by March 1. Among its other attributes, the majority of delegates saw the bipartisan commission as a method of minimizing the gerrymandering of districts. Others would comment that the bipartisan commission would insulate legislators against a claim of conflict of interest. Legislators would not be apportioning their own districts, although legislators could serve as delegates. Ceding appointment power to the state political chairs recognized the statewide political nature of the process, and equal party representation provided a check against a scenario where the majority party could control the apportionment process for 2 decades. And finally, the appointment of the 11th member by the Chief Justice suggested that the convention sought fairness in the outcome of the process. The Constitution also included 4 mandates, 4 standards, that would be applied during reapportionment: equal population, compactness, contiguity, and respect for county and municipal lines. Exceptions were made for counties and municipalities whose population exceeded 1/40 of the state population. As applied to municipalities, only Newark and Jersey City would be affected. By 1966, the first commission was in place. Soon thereafter, a stalemate occurred, and the commission notified Chief Justice Weintraub that an 11th member was necessary. In a pattern that would continue for the next 5 11th member appointments, the Chief Justice selected an academic, Dean Marver Bernstein of the now renamed School of Public and International Affairs at Princeton University. During the 1-month period with the 11th member, the commission agreed on a compromise map, but in Jackman versus Bodine 5, the court performed a detailed analysis of the districts and concluded that the map was unconstitutional as population deviations exceeded constitutional tolerances. After remanding the map to the commission for revisions, in Jackman 7, the court questioned the conflict of maintaining county boundaries and fulfilling the mandate of population equality. Finally, a new plan was submitted to the court and approved in Jackman 8, in time for the 1969 legislative elections. The initial 1966 apportionment effort came to an end, but a few years later, a census-driven 1971 legislative apportionment was looming. The initial commission struggled with unmooring itself from the reliance on the dominance of counties in the political process. Yes, Jackman had upended the 1844 constitutional provision that apportioned 1 senator to each county, but still the newly enacted amendments focused on the preservation of county dominance. Counties were seen as the building blocks for apportionment. From a political perspective, county organizations were dominant and were critical to New Jersey's political infrastructure. The 1971 Commission would not yet extricate itself from the old model. The 1971 Commission, by a 9-to-1 vote, agreed on a map without the necessity of an 11th member. Yet, that map too did not survive constitutional scrutiny. The decisive issue again was the constitutional requirement that where possible, districts consist of whole counties, a critical consideration in the 1966 Convention Compromise. But as the court considered the newly proposed map, honoring the constitutional concept of whole counties conflicted with the overriding principle of 1 person, 1 vote. The court, again with Chief Justice Weintraub as the author of a series of opinions, first in Scrimgeour versus Sherwin and later in Davenport versus the Apportionment Commission 1, informed the commission as to what the law is. The requirement of whole county districts was no longer a viable constitutional standard. The opinion in Davenport 1 would be Chief Justice Weintraub's last opinion addressing apportionment. But his writings for the court in Jackman, Scrimgeour, and Davenport 1 would be the legacy of the early apportionment process and would be the core for decisions addressing future maps. Finally, the 1971 Commission map was approved in Davenport 2. The opinion would be written by Justice Mark Sullivan for a court now headed by Chief Justice Richard Hughes. While he did not write the Davenport 2 opinion, Chief Justice Hughes was well acquainted with the apportionment process. As governor, he never attended the 1966 convention, but his strong views were well presented by a highly respected delegate, David Goldberg from Trenton, acting on the governor's behalf. And it was through the governor's substantial influence that the compromise resulting in the constitutional amendments was supported by the Democratic delegates. Davenport 2 would mark the end of the post-convention decisions, and although successor courts would weigh in on other apportionment issues, these initial cases would set the framework for the future. The 1981 and 1991 commissions would again require the appointment of an 11th member. In both instances, consistent with the earlier appointment of Dean Bernstein, Chief Justice Robert Wilentz appointed another academic, Dean Donald Stokes, again from Princeton University. In 1981, Dean Stokes would make history, as with a divided commission, he would be the first 11th member to act as a tiebreaker, to cast his vote in favor of a partisan map. In reflecting on his experience as the 11th member, he made a critical observation. He noted that he was unable to achieve a consensus map because of his late appointment as the 11th member, 1 month before the map was required to be filed. Time prevented him from working with the parties to resolve the nuanced differences between the partisan maps. He suggested that the final map was generally agreed to by the parties, but political realities caused the delegates to split 5-5 on the final vote, prompting him to cast the 6th vote for the Democratic map. 10 years later, in 1991, another tiebreaker was required. This time, Dean Stokes would cast the tie-breaking vote for the Republican map. In 2001, Chief Justice Porras would choose another Princeton professor, Larry Bartels, to serve as the 11th member. He would cast his vote for the Democratic map, but the vote would be 6-1, as 4 of the Republican commissioners boycotted the final vote. This map withstood challenges in the federal courts, but a more significant challenge was resolved by the New Jersey Supreme Court in McNeil versus the Apportionment Commission, where Justice James Coleman, writing for the 4-3 majority, concluded that notwithstanding the constitutional provision allowing the splitting of Newark and Jersey City into 2 districts, the adopted map properly divided Jersey City and Newark into 3 districts. The reason advanced for the deviation from the Constitution was compliance with the provisions of Section 2 of the Federal Voting Rights Act of 1965, as well as the Supremacy Clause. The McNeil decision would later play an important part in the promulgation of the 2022 map. The next decade saw the commission agreeing on the 11th member, and in 2011, Chief Justice Ravner appointed Professor Alan Rosenthal of Rutgers to serve in that role. At the end of the process, Professor Rosenthal cast the tie-breaking vote to provide for a 6-5 majority for the Democratic map. The challenge to the map would be rejected by the Appellate Division in Gonzalez versus the Apportionment Commission, and in an opinion written by Judge Mary Catherine Cuff, the Appellate Division rejected a redux of the county argument previously rejected in Scrimmager and Davenport. In all instances since Davenport won, all of the maps that had been decided by the 11th member as tiebreaker withstood a court challenge, a contrast with the earlier 1966 and 1971 consensus maps that in each instance failed to survive judicial scrutiny. Much of this seeming disparity in outcome is attributable in part to the evolution and development of the law and the New Jersey Supreme Court decisions from Jackman to Davenport, establishing priorities as to the constitutional apportionment standards, as well as the population deviations that would conform to the overarching principle of 1 person, 1 vote. The Supreme Court would tolerate a 10% deviation, while the New Jersey Supreme Court looked to 5% as an acceptable population deviation. At this point, I'm going to take a bit of a detour and briefly address the sometimes public confusion about the differences between the structure of the Apportionment Commission and the New Jersey Redistricting Commission, charged with the responsibility of restricting the congressional districts rather than state legislative districts. First, these are 2 different independent commissions that operate under different provisions of the Constitution. Unlike the Apportionment 10-member commission, the Redistricting Commission consists of 13 members, with the selection made by legislators and party leaders. The 12 partisan members, 6 from each party, then elect the 13th member, and if they are unable to do so, they advise the Supreme Court of the impasse, and each side then submits one name as a potential 13th member. Unlike the Apportionment Commission, the Supreme Court as a whole, not the Chief Justice, selects one of the two names, and the 13th member is made the chair of the commission. While the Redistricting Commission and Apportionment Commission are bound by similar constitutional mandates, there is one key substantive difference. The Redistricting Commission is not bound to honor municipal boundaries and may split municipalities. Part 2, the Apportionment Commission, 2021 to 2022. I raise the distinction between the two commissions now, as in recent years there have been attempts to recast the Apportionment Commission. In 2018, a legislative initiative changing the selection, structure, and operation of the Apportionment Commission, including increasing the commission to 13 members, never made it to the ballot. A few years later, in 2019, a group of 6 renowned scholars, including Professors Ron Chen here at Rutgers and Professor Sam Wong at Princeton, who would later serve as part of the 2021 Apportionment Commission team, and others, called for a 13-member commission, including 3 independent members appointed by the Chief Justice. The proposal also examined and reprioritized the standards that had been included as part of the 1966 constitutional amendments and added additional standards. While many of their suggestions still warrant serious consideration, one critical recommendation found its way, in part, into the Constitution: the early appointment of the independent member, a position previously urged by Dean Stokes. The scholars' recommendation, together with a late delivery of the census and the pandemic, generated an amendment to the Constitution. The 11th member would be appointed in October 2021 instead of March 2022. The impact of the amendment was immediate. In September 2021, the census report was received by the governor. The commission had notified the Chief Justice earlier of the need for an 11th member, and as was his practice in the last apportionment cycle, resulting in the consensus appointment of Alan Rosenthal, Chief Justice Rabner asked the political chairs to submit to a retired justice designated by the chief a list of proposed 11th members. The names would remain anonymous, even to the Chief Justice. If advised that there was a match, the Chief Justice, as he had done 10 years earlier, would probably appoint the agreed-upon name. Unfortunately, despite the care taken to shield the potential nominees, the names were leaked to the press and became public. For this cycle, the parties submitted separate lists totaling 11 names, including retired justices and judges, former cabinet members, and academics. No common name appeared on the list. The Chief Justice then appointed what I proudly refer to as the 12th choice to serve as the 11th member. On October 7th, 2021, I was appointed as the 11th member. The appointment broke the pattern of the past. The 5 prior appointments were all political scientists with an expertise in apportionment. All of them came with a studied view of the process and standards. Each would openly advance a particular area of emphasis in their deliberative process. Dean Stokes emphasized partisan fairness, Professor Bartels focused on minority representation, while Professor Rosenthal agreed with partisan fairness but also added continuity of representation and preserving core districts as critical concerns. Let us look at what happened from October 2021 until the adoption of the map in February 2022. Let us examine what the Commission did, how we did it, and what decisions were made in the process. We start by acknowledging that the schedule for the next 4 months was relentless, filled with intensity, challenges, and ultimately immersion in a process that few, except those interested in the outcome, are fully familiar with. Each day, a new issue or even crisis would emerge that would prompt a response, a Zoom meeting, a consultation with counsel the commission, co-chairman, their attorneys or staff, or even the whole commission. I came to the process with neither the academic background nor the political science expertise of my predecessors. My early appointment gave me some immediate advantages. It allowed me to reacquaint myself with the relevant law, and I will tell you that my learning curve was vertical. Speak to those who had been involved in the process before, meet with representatives from the Office of Legislative Services charged with fulfilling the myriad administrative tasks required in the process, and of course, introduce myself to the commission co-chairs, their attorneys and staff, and the commission itself. At my first meeting with the commission, I described my objectives. I told them that the best outcome would be a consensus map agreed to by the parties. But being realistic, and short of that, I would hope that the maps would be so close as to make my vote a difficult one. One thing I learned quickly, despite the 11th member just being a single member of the commission, the position carries with it a direct role in the process. As the potential tiebreaker, the 11th member can significantly influence the functional performance of the commission. One of my earliest priorities was to assemble a staff, and as I knew from my years at the bar, the first thing one always needs is a good lawyer. I had a number of extraordinary candidates from in-state and out. I settled on a young man who proved to be more than I could have anticipated, Andrew Gimigliano, and Andy came with stellar credentials. He's here, by the way, so I'm embarrassing him a little bit, but it's okay. He graduated magna cum laude from this great law school, was editor-in-chief of the Rutgers Law Review, and had clerked for another proud Rutgers Law graduate, Justice Janie LaVecchia of the Supreme Court. But what set him apart from the other candidates was while as a law student, he had served on the legal staff of the chair of the 2010 Congressional Redistricting Commission, John Farmer. Unlike me, and to quote Lin-Manuel Miranda, he had been in the room where it happened, and that proved to be invaluable to me. Andy served as my sounding board and advisor on every, and I underline every decision, made over the next 4 months. And of course, he was charged with the responsibility of talking me down off the ledge when the circumstances required it. Andy reached out to Professor Chen here at the law school's Constitutional Law Clinic, and John Farmer, now heading the Eagleton Institute of Politics at Rutgers. Rutgers Law School and Eagleton students would assist us. Their service proved invaluable. We had our legal team in place, and our next effort was securing our experts. We likewise had a number of candidates from across the country, but retained the services of Princeton professor Sam Wong and the Princeton Gerrymandering Project. Sam had a nationwide reputation as an expert analyst of election maps and had been involved in other state reapportionment and redistricting efforts. He brought together a team of smart people whose analytic skills were critical to our work, including a retired lawyer, Rick Ober from Princeton, who focused on the issue of communities of interest. We also had on the team an 18-year-old Eagleton student by the name of Kevin Chung, whose skill at map drawing and analysis defied his age. This was our team. As I mentioned earlier, consistent with the Constitution, the makeup of the commission was partisan. 5 Democrats, including a former state senator, Steve Sweeney, and 5 Republicans, including 2 legislators, now Congressman-elect Thomas Kane Jr. and now Senator John Bramnick of Union County. The other commissioners were from all over the state, but the most important and critical players were 2 extraordinary men, the respective chairs of the 2 delegations. Al Barlas, the Essex County Republican chairman, headed the Republican delegation, and Leroy Jones, the state Democratic chairman, headed the Democratic side. These were two very smart and politically savvy individuals who knew the politics of New Jersey down to the details of every hamlet and burg in the state. What was critical was that they knew each other and they trusted each other's word. They were strong advocates and fierce advocates for their position, but they could talk to each other. This presented a challenge for me. They had no idea who I was, and my objective was to build trust with them. I told them up front that I would be completely open and candid with them. If I was going to announce an initiative, they would hear about it first. I would not be issuing press releases, and any public statements from me would be seen by them first and would be made on the record at a public hearing rather than conversation with reporters. As I anticipated, they vetted me as well, as they were both bringing me regards from people I had not seen or spoken to in sometimes 20 years or more. They too brought with them a solid team of lawyers, experts, and professional staff who worked hard with us in achieving this important outcome. The commission work started in earnest. As I mentioned earlier, there are standards that must be followed in apportionment. While the Constitution sets out 4 mandates to be adhered to, through its decisions, the New Jersey Supreme Court has eliminated some or modified the rigid application of others. The commission was entitled to know how I weighed the standards, and with Andy, I drafted and presented to them a 14-page document of the requested information. I will spare you the full document and simply provide the executive summary. These were the standards that we said would be applied. The districts must be of equal population of 232,362 people with a general deviation tolerance of 5%. The districts must be contiguous. All parts of a district must connect with each other. 3, while districts must be as nearly compact as possible, the Weintraub court had minimized the importance of this standard, and it would yield to population equality. Municipal boundaries must remain intact, with the exception of Newark and Jersey City, which under the Constitution could be divided into 2 districts. There were additional constitutional requirements. These were the constitutional requirements, but there were additional principles that were developed from federal law, case law, and historic practice. They were included in my statement. 5, the map must comply with Section 2 of the Voting Rights Act of 1965. This map would include opportunity to elect legislative districts that provide minorities with a reasonable opportunity to elect representatives of their choice. This was especially important in a state with a 48% minority population. The map would reflect communities of interest. I offered a more expansive definition of communities of interest than had been used before. In addition to ethnic, cultural, religious, or linguistic communities, we added communities that shared economic, infrastructure, environmental concerns, or shared industry. I included district competitiveness as an important standard, but cautioned that competitiveness in all districts was unrealistic. I included continuity of representation as another standard, but again, it could not be the dominant factor to the exclusion of others. Lastly, I included the somewhat elusive standard of achieving partisan fairness, a standard emphasized by Dean Stokes that promotes fairness between the parties and considers the relationship between popular support and control of the legislature by examining the outcome of past elections. The document discussed the standards in depth, but strongly emphasized that they were integrated. No one standard could be applied without consideration of the others. I informed the chairs that I would be announcing the standards at the next public meeting, but consistent with my commitment to them, I sent them a statement the day before the public meeting so there would be no surprises. They were received without comment and announced the next day. Not specifically addressed in the public document, but discussed within the commission and our team was the issue of gerrymandering. A bit of history. In 1812, the governor of Massachusetts, Elbridge Gerry, drew the state Senate redistricting map to favor his political allies in the upcoming election. The map was the subject of a cartoon in the Boston Gazette, and the term gerrymandering, a portmanteau of Elbridge Gerry and a salamander, became one of Gerry's signature contributions to history. The term stuck and describes districts that are designed to favor a particular political party. Gerrymandering has a well-earned negative connotation when advancing partisan political objectives, and partisan gerrymandering can skew election results to create an unfair outcome in favor of a political party. Nevertheless, the United States Supreme Court recently held in Rucho versus Common Cause that a legal challenge to partisan gerrymandering is non-justiciable, hearkening back to Colesgrove versus Green. However, there is at least one instance where gerrymandering in part plays an important positive factor, and that is to ensure compliance with Section 2 of the Voting Rights Act. The practice of gerrymandering exposes two negatives that must be considered by all map drafters. As the Brennan Institute at NYU describes it, most attempts to gerrymandering can best be understood through the lens of two basic mapping techniques, cracking and packing. To explain, cracking splits the group of people with similar characteristics, such as voters of the same political party or racial groups across multiple districts. With their voting strength divided, these groups struggle to elect their preferred candidates in any of the districts. Packing is the opposite of cracking. Map creators cram certain groups of voters, such as minorities, into as few districts as possible. In these few districts, the packed groups are likely to elect their preferred candidates, but the group's voting strength is weakened everywhere else. While neither packing nor cracking were mentioned specifically in the standards, we were sensitive to minimizing the impact of these two factors. After our recurring meetings with the chair and council, points of contention emerged. Among them was the issue of what data was going to be used in drafting maps. Obviously, the results of past legislative elections were relevant, but how many past elections should be considered? Should we go back 3 elections, or should we go back a decade, 5 elections since the last map? Should the results of federal elections be considered? Were they relevant to our deliberations? In my view, wherever the negotiations led us, everyone would be exchanging and using the same data, and after much discussion and negotiation, that is what happened. Then there was the issue of metrics. What statistical methodology would be used for analyzing the data? This would not be a negotiation. The parties had different methodologies, and they were free to analyze the data using any method that they deemed appropriate. But they pressed me to reveal how our experts would be analyzing the data to arrive at a decision as to which map to support. Ultimately, the issue became moot, as the movement towards a consensus map would obviate our need to go further on the issue. Nevertheless, as the process unfolded, I relied on Sam and his team to advise us as to whether the maps were meeting the standards that I had presented to the parties. Sam had developed a methodology for scoring the maps internally. A fair map would treat the major political parties symmetrically. For example, if they were to switch places in terms of the number of votes won statewide, they would ideally switch overall outcome. Sam's team used computer simulations and formulae to arrive at a fair map. Even the description of the process is daunting, but I'm pleased to report that using Sam's model, the final map scored well. We then moved on to another issue which proved to be far more contentious and ultimately impactful. I advised the chairs that I wanted to release proposed maps to the public for comment. This had never been done before, and it generated strong resistance from both sides. I had prepared a public statement regarding the release to be presented at the next scheduled public meeting. I circulated it to the chairs and council, but after some discussion, I agreed to delay my public statement to allow all of the players to weigh in. Over the next few days, we discussed the nature of the maps, final versus preliminary, timing, how it would impact on our constitutionally mandated report date, and other related issues. After some extensive and in some instances, spirited negotiations, I actually learned a few new words that I had never heard before. We reached an agreement as to the release. Each delegation would present a separate map for release to the public. The next issue provided the comic relief that often follows any difficult negotiation. I informed the parties that I did not want a party label attached to either map. The issue became, what do we designate the map, each map? We met with both sides and opened the floor for suggestions. Some of the proposals included naming the maps after the first New Jersey governors, James Patterson and William Livingston. It was rejected since we had cities of those names and it would be confusing. The second was Case pork roll versus Taylor pork roll. I exercised my veto power because, as I explained, I would have to answer to my late mother as to why I was agreeing to a pork product. The next was Springsteen versus Bon Jovi. As much as the public would have enjoyed it, it was rejected because of their political views. Finally, we agreed on the labels, pure vanilla, the Turnpike map versus the Parkway map. For the first time in apportionment history, preliminary maps from the Apportionment Commission were presented to the public. Of course, within minutes of the release of the maps, the media easily identified which party generated which map. Nevertheless, it had its intended impact. The public response to the maps was overwhelming, and 2 public hearings were scheduled to hear the comments from 160 people who registered to speak at these 2 meetings. The commission held a record number of 11 public meetings, with all but 2 on Zoom. The hearings were particularly helpful in identifying communities of interest. We learned, for example, about the rich history of the Arab populations of Patterson and Passaic County, the importance to the African American community of linking Merchantville, Pennsauken with Camden, the linkage between Vineland, Millville, and Bridgeton to the Hispanic community, and linking Freehold with the shore communities in Monmouth County, as well as the influence of the Asian communities in Middlesex, Somerset, and Mercer counties. I cite these as just a few examples. In all, hundreds of people testified at our public hearings or submitted comments and maps. We heard, we heard from high school, college, and graduate students, politicians, ethnic and religious groups, and most important, just New Jerseyans who wanted to participate and have an opportunity to weigh in as to what we were doing. In addition to the public hearings, we met with interest groups who shared their views with us. One group proved to be especially well organized and substantive. The Fair Districts Coalition, an extraordinary amalgam of various ethnic, racial, and nonpartisan organizations, met with us and presented a listing of communities of interest, and then exhibited a map to the entire commission, reflecting a coalition of minority groups, again representing 48% of the New Jersey population. These were smart, talented, and thoughtful advocates whose hard work and advocacy had an impact on the final map. We had citizens providing maps using free, statistically reliable software that was readily available on the internet. Andy had told me that 10 years before, maps were being drawn with magic markers. For this cycle, the maps submitted by the public were computer assembled, sophisticated, and plentiful. As in any political process, there were diversions, not directly related to the work of the commission. On January 29th at 6:30 a.m., I received a call from Andy that Senator Sweeney was being removed from the commission. Senator Sweeney then filed a lawsuit seeking reinstatement as well as an injunction against the commission. Our position was simple. The removal issue was an internal political issue. We would take no position on the merits, but we would oppose an injunction. Ultimately, the lawsuit was dismissed. A second sideshow involved a series of escalating press attacks against our expert, Sam Wong. It is difficult to refrain from engaging with the press and answering spurious allegations, but as I had been taught through my experience at the administrative office of the courts, never make a one-day story into a three-day story. It was a difficult time for Sam, but we assured him he was our expert, and eventually the press went on to other things. We went back to business. I mentioned that there are two exceptions to the unified municipality rule. Newark and Jersey City can be split into two districts. However, as I mentioned earlier, in the McNeil case, the court allowed a split of the cities into three districts. During our deliberative process, this became an important issue. Were we willing to split Jersey City into three districts? I determined that notwithstanding McNeil, I was reluctant to support this split. The argument to split it was to preserve a minority district consistent with Section 2 of the Voting Rights Act. My decision, in part, was premised on a legal development taking place away from New Jersey. Earlier in the week, the United States Supreme Court, in a case called Merrill versus Milligan, granted a stay against the enforcement of a three-judge court order requiring Alabama to generate a map creating two majority-minority congressional districts. Even though no reasons were given for Justice Thomas granting the stay, in a concurring opinion written by Justice Kavanaugh and joined by Justice Alito, together with a dissent by Chief Justice Roberts, the viability of Section 2 of the Voting Rights Act was an issue. Andy and I spent a great deal of time discussing the cases and worked with our technical staff, including our 18-year-old map maker, and concluded that a map could be drafted to preserve the minority districts in Jersey City without the necessity of the three-way split. While Merrill was a congressional redistricting case, we had little doubt that the United States Supreme Court at some point would question the Voting Rights Act as applied to state legislative districts. The New Jersey state map could be jeopardized, and we said no. In the end, the final map was drawn, consistent with the Constitution, with only a two-way split. The last week of the commission deliberative process is called Hotel Week. All of us, commissioners, council, staff, closet ourselves in a hotel and go nonstop until we reach a resolution. Time and privilege prevents me from going too deep into the weeds as to what transpired during Hotel Week, but I will try to give you a sense of what happened. The first day, February 15th, was Map Immersion Day. Consistent with my past practices, I met with the co-chairs to discuss the agenda for the day. I would first meet with the commission as a whole, and then we would hear map presentations from each side, adjourn and reconvene to offer comments about the proposed maps. With the chairs, we discussed procedural issues as each side exchanging maps with each other, another first, and the nature of the presentation, as well as more subjective issues. Everyone agreed that the interactions would continue to be professional and the tone would reflect that objective. Finally, we agreed that we would continue a discussion that the co-chairs and I had started earlier during the process, the possibility of a consensus map. The rest of the day followed the agenda with extensive discussions of various map proposals, our team's reactions, and the redrafting of maps. Each iteration of a map requires detailed analysis of each of the 40 districts, which must be scrutinized to make sure that they fit in the total picture, and within a district, there are nuances that serve as justification for a proposed change from the past. Each adjustment requires readjustments in other districts. During the week, I would meet individually with delegations, but most regularly with the chairs. Issues arose on the hour that required our input, but it became apparent that we were operating on two tracks. The parties were developing their own partisan maps. Our team analyzed, scored, and prepared comments for each iteration. At the same time, we were focusing on the partisan maps. The negotiations for a consensus map became more intense. These are two different role plays for the 11th member. One is advocate, and the other is mediator, and both come with a vote as a member of the commission. Any discussion with the chairs always circled back to the issue of a consensus map. But time was running out. We had a deadline for production of a final map. As with any negotiation process, there were constant ups and downs. One moment we were making progress on a consensus map, and the next day we had no chance for an agreement. And we were calling on the parties to produce their final partisan maps for analysis, where I would cast a vote. Then late on Thursday afternoon, it all came to a head, when the parties indicated they were close, but at an impasse. Much of the disagreement stemmed from Democratic and Republican views of the final map, but we also intuited first and then confirmed later that there were significant internal conflicts within the caucuses. My role now shifted again. I now had to meet with and champion the commission as a whole. I explained how unique and important the moment was. The commission was on the cusp of history. This was an opportunity to control one's destiny. The time was now. And finally, after speaking to the commission as a whole, I said they had 1 hour to resolve the issue or produce their competing maps, as I was preparing to make a call on a map that neither side would be happy about. Since my appointment, I kept a detailed journal recording my experiences as the 11th member. The entries for each day of Hotel Week run many pages, but the entry for February 18th, 2022 at 6:10 p.m. has a page of its own. It contains one word: deal. We had a map. There was still lots of work to do. We spent the next 4 or 5 hours reviewing the proposed consensus map. Our team scored the map, and the commission made history, a consensus map that satisfied all of the constitutional and court-imposed mandates. The next day, on February 19th, 2022, the New Jersey Apportionment Commission met in Trenton and voted by a bipartisan vote of 9-2, 4 Democrats, 4 Republicans, and me, to approve a new legislative map. 1 Republican and 1 Democrat voted no. One newspaper wrote that the vote was an unprecedented compromise for a commission that has historically relied on a court-appointed tiebreaker to end partisan gridlock. This map takes effect for New Jersey's 2023 legislative elections. The reactions to the map were positive. Chairman Barlas and Chairman Jones, whose leadership made this result happen, expressed pride for what had been accomplished, recognizing that a result like this generates hard and tough decisions, especially by them and their delegations. As expected, there were never negative reactions, especially that the map fell short of the Fair District Coalition goal of 20 majority-minority districts. But the map had a record number of 17 of such districts, with 2 more providing a realistic election opportunity for minorities. With the reflection that time affords, the most important outcome is that the process worked as intended. The Constitution provides for a system where the Commission can agree on a map without the 11th member serving as the tiebreaker. All that is necessary is that a majority of the commissioners agree. That is what the drafters envisioned, and that is what happened. We achieved some unique firsts: a record number of public hearings, the first public release of maps for public reaction and comment, and a consensus map that was never challenged in the courts, but unlike consensus maps of the late 60s, a map that meets the standards imposed by the Constitution and the courts. For me, it proved to be a unique experience. I was exposed to 2 fierce and strong advocates in Chairman Barlas and Jones. true leaders and gentlemen who, despite the tensions and pressures of the moment, were respectful, civil, candid, and tough, but fair and seized the moment to make history. I was fortunate to have an extraordinary lawyer and an extraordinary map expert and an extraordinary team that worked hard and well together, spoke its individual minds openly and candidly, and never lost sight of our role or purpose. The Brennan Institute has noted that done right, apportionment is a chance to create maps that, in the words of John Adams, are an exact portrait, a miniature, of the people as a whole. Was the map perfect? Did we produce an exact portrait of New Jersey? No. There will never be a perfect map. There will never be a perfect portrait. What was accomplished is a fair map, a constitutional map, a bipartisan map approved by commissioners on both sides of the aisle, a map designed to last for a decade, and for that we are proud. Thank you. I think I'll leave it.
We'll open it up for a few comments and questions to the audience.
Yes. I think I recognize you. Well, thank you. Great question, I will say that. Number one, as I mentioned earlier, the commentary on the Constitutional Convention and the wisdom of placing the Chief Justice in that position, which is not always a comfortable position, and has become partisan because the appointment becomes the Democratic appointment or the Republican appointment, depending on which map is chosen. But the original idea in the minds of the convention was that that was a sign of fairness, because now they had an independent appointment made by someone who was completely independent of the process. Having said that, I think history has shown us that it places Chief Justices in a very difficult position, especially when things go off the rails. There have been a number of suggestions that have been made as to how to remedy that circumstance, but it means changing the nature of the commission. And what you have seen in other states is that we have independent commissions selected through various different ways, and that takes the court out of it, it takes the legislature out of it, no appointments are made that are political in nature, and the commissions exist. I will tell you that I think there is an issue now before the Supreme Court that's going to be argued next week on December 7th. I guess that's 2 weeks. And that's the Moore case, and that may put into question the nature of the commissions that can be involved in congressional elections, and we'll wait and see. But other than changing the commission itself, I don't think that there's any interest in extricating the Chief Justice from the process. The 2019 suggestions that were made by Professor Wong, who's on my left, and Professor Chen on my right, and Professor Chen on my left, talked about a 13-member commission with the Chief Justice making 3 appointments. So that doesn't make it any easier. There are other methodologies that can be used. Each party selects an independent, and then the 2 independents choose the 3rd independent, and then the question becomes what happens if they can't agree. So I'm sad to say that the answer right now is the Chief Justice is probably going to continue, short of changing the entire structure. Justice Stein. Well, 3 parts to the answer. Number one, the issue that you raised is exactly the issue that Chief Justice Rabner raises. Number 2, the 1971 Apportionment Commission agreed on a map without a tiebreaker. It was the commission voting 9-1 to agree on a map. The map on its face was unconstitutional for the exact reasons that you suggested. It was preservation of seats, but more important, it was adherence to this county model, where counties had to be kept whole and so forth, which was untenable under one person, one vote, and that's what Chief Justice Weintraub eventually said in Scrivener and Davenport 1. Is there a better model? Well, a number of states have adopted the independent commission model. So you have California, you have Michigan. Ron, you know the other 2, or maybe Sam, you know what they are. There are Arizona and what was the 4th? Colorado. So there are independent commissions. They are chosen with different methodologies, none of which involve the Chief Justice. But and they work. And if you review them, some of the selection processes are fascinating because any citizen signs up and can be chosen to serve on the commission. So it's certainly worth exploring. Realistically, is the state legislature going to act to give up the ability to be involved in the apportionment or redistricting process? I don't think so. But there's another overriding issue that's critically important. It's a political process. And the convention in 1966 recognized it's a political process. Now, what has happened since that time, from 66 to now, is a recognition that there are interests beyond simply politics that have to be responded to. And, you know, the Voting Rights Act had been passed by 1966, but the emergence of more concern and more recognition of the importance of recognizing minorities and so forth. And then you get into New Jersey. New Jersey's 48% minority. You know, so all of this is in the mix, but there are other ways of doing it, but it's going to take a tremendous effort to get the legislature. This is just my view, to get the legislature to move off what they have now. Yeah, Jack. Justice, excuse me. You know, I wish the accolades stopped there without the question. It's going to be much easier. The answer is yes. I don't think I can pinpoint any one thing at the moment. I know there are those sitting in this audience. Henel Patel was the head of the Fair Districts Coalition, and she's seated in the first row. And she's going to be looking a lot closer at many of the districts that were created to see how it turns out. I have to add one thing that is important. It's not a direct answer to your question. Co-chairs Barlas and Jones play a game of fourth dimensional chess, which I am not fully familiar with. So many times, especially when you get in a consensus map mindset, many decisions are made which are perfectly legitimate in terms of our analysis of the maps that have political implications that are well beyond, you know, we say pay grade, but you know what I'm talking about. And there was some of that here. So I think at some level, the political folks will be looking at these election results much closer than we will. There are certain districts I'm just interested to see how they turn out as a general list, but not a studied interest by any means. Yeah, Justice Alpin. no dog in the fight. I'm just interested to see at some configurations. But you point out something in your question that is critically important. I close my remarks by saying this is a map for a decade. When this process is going on, one of the concerns that we had, Andy is sitting over to my left, and Sam was part of this as well, is the thought process that we're going through now simply concerned with the 2023 election? Or are we worried, should we be focusing on the next 10 years? Because your question implies correctly that there are the vicissitudes of the process. Elections happen, issues come up, things you can't anticipate come up. But what is it going to look like over the long run? What is it going to look like for 10 years? And much of our thinking was, we're doing a 10-year map here. We're not doing a 2023. We're doing a map that has to be used in 2023, but our thinking has to be much broader than that. So do I have any particular concern about the outcome of the election? Not really. But I am interested because certain districts were created that we want to just take a look and see how they come out. Great. Thank you.
Well, Judge Karchman, on behalf of Rutgers Law School, the Alumni Association, and the Rutgers University Law Review, thank you so much for your insightful remarks. I hope that we can continue to have conversations about Judge Karchman's speech tonight upstairs during the reception. Thank you again for being here.